Barrett versus Barrett. You want to reserve any time?
Yes, Your Honor. 7 minutes. My name is Sharon Lee Stedman. I'm from Orlando, and I represent the former husband in the instant case. And the appeal arises from a dissolution of marriage proceeding in the trial court. And the main issue, well, the only issue before the trial court was the equitable distribution of the parties' marital assets and liabilities. The statute that applies to this case is Section 61.075, which starts with the presumption that all marital assets acquired during the marriage and liabilities incurred during the marriage are to be, it's presumed that they shall be divided equally, unless there's some extraordinary circumstance that would allow the trial court to divide the marital assets unequally. The trial court in this case gave, he said 90% in the final judgment to the former wife, which basically amounted to 100% of the marital assets to the former wife, other than the house, the marital home, which was divided prior to the trial. In this case, the trial court made no legally valid sufficient reasons for this type of marital distribution. He found that the former husband did not contribute to the marriage, that he was wasteful, that he was a spendthrift. But what the facts of this case actually show is in the early years of the marriage, and it's real important that this court noticed that everything was talked about in the latter part of this marriage. Well,
these were findings of fact that he made, right?
Right, Your Honor.
Was there substantial competent evidence to
No, Your Honor. There was neither a legally valid reason that the trial court stated in the final judgment for this inequitable distribution.
No, I mean, I'm not talking about the inequitable distribution or the equitable distribution. What I'm talking about is the facts about your client not being the breadwinner, not contributing to the household, that sort of thing.
No, Your Honor, because the only thing they ever talk about is the latter years of this marriage. This was a long-term marriage. This was a marriage that lasted 22 years.
But, Counsel, are you suggesting in your argument that he's got to be a spendthrift during the entire time of the marriage? That he's got to be the way Judge Sprinkle described it, throughout the entire marriage? Or?
Well, you need to look at the entire marriage since it is a long-term marriage, Your Honor.
Well.
And what this case shows is that the former wife even testified that she could not testify that any of this occurred in the early part of the marriage. They both earned approximately the same amount of salary, about $25,000 a year. They moved to Florida. She got a job with the Chrysler, which was unionized, and she said this. She testified. I'm taking her testimony. And she testified that because she was union, that she all of a sudden, her salary started going up. Well, he was not unionized. He was a painter. His salary remained the same throughout the marriage.
Counsel, what you're doing, and you're asking us to reweigh evidence. That's really what you're doing.
No, Your Honor, I'm not. I'm asking the court to look at the entire marriage. And this is her testimony.
But in order to look at the entire marriage, in your view, in your light, you're asking us to reweigh evidence.
I'm just asking, Your Honor, to use the correct standard of review, the correct standard that's applied to a long-term marriage. There's some marriages where
what is that standard, Counsel?
That you look at the lifestyle during the marriage, not the latter.
That's not a standard.
But, I mean, it's during the marriage, a long-term marriage. Your Honor, if I could just, in a lot of cases, the former wife will work.
Answer me the question first. What is the standard of review with respect to the findings of fact in this trial?
If there's competent, substantial evidence to support the findings of fact, then this court must affirm.
Okay. So if we find any substantial competent evidence in the record, that game is over.
Your Honor, that's true as to that portion, but the portion that I'm talking about is whether or not there's a legally valid reason for the disproportionate equitable distribution, which is a legal standard. The trial court, what I stated in my brief, was he did not come up with a legally sufficient valid reason for the unequitable distribution of these parties' assets. And also the trial court found that the husband didn't contribute to the family finances. It was all the former wife during the latter part of the marriage. But if in 1998, the one big marital asset of these parties was a marital home. The former wife testified that he sold a lot in Jamaica. There are actually three different lots, but only two to be talked about. One he claimed was his mother's home, and then there was another lot that they both agreed was his. And in 1999, he sold his lot.
Considering the equitable distribution, the trial court set out the factors in 61075 and made some findings, one of which is the economic circumstances of the parties. And the trial court specifically found that the husband's income has been sporadic and reflects a lack of consistency, whereas the wife has clearly been the steady breadwinner for the majority of the marriage. And you're saying that those findings are not supported by the evidence in the case?
I'm saying those are not legally sufficient.
Well, it's one of the factors that the trial court extracted from the list of statutory factors in the statute I just cited to you. But I guess my question is, you're saying that there's no evidence in the record to support the findings that the husband's income was sporadic and the wife was basically the breadwinner for the duration of the marriage.
At-home housewives and mothers would never get equitable distribution under this trial court's reasoning, Your Honor. There's normally one spouse that is the breadwinner, and that's the whole point of this. If you based it on who earned the most money, and what the trial court...
That is one factor, though, but I guess my question to you is, if we find that there's evidence in the record to support that factor, that would be a sufficient factor to consider along with the others listed in the statute, right?
If the court could possibly rule that that's legally the law in the state of Florida, it could rule that way.
Well, is that one of the factors that the trial court should consider under 61075, subparagraph 1?
Yes, sir, Your Honor, but the law under that statute.
I mean, but it's a consideration, isn't it?
Yes, Your Honor.
And is there evidence in the record to support those findings?
No, Your Honor, and if I could just explain, when the marital home was built, he sold his own premarital lot in Jamaica, $65,000, put it into the marital home. He personally built for a year. He was on site, he supervised, he constructed that marital home, which ultimately sold for $630,000. Now, I would say that that's a contribution, economic contribution to the marital assets. I mean, that was $630,000. Of which he put his own time and his own labor and $65,000 of premarital assets. And those are the years that the trial court's talking about. The wife was earning $50,000 a year. The husband contributed $630,000 to the marriage.
But there's a finding in the final judgment that says there's very little evidence that the husband contributed to the family finances throughout the history of the marriage. And then the situation got worse as the relationship soured. I mean, that's a finding too, isn't it?
Your Honor, that's a finding, but that's not supported by the evidence, because the former wife testified herself that they earned approximately the same amount until they moved to Florida.
Counsel, when you say it's not supported by the evidence, you're saying it's not supported by your side of the evidence.
No,
There's evidence on the other side, though, that would support it.
I represent the former husband. The former wife testified that during the marriage, during the early part of the marriage, until they moved to Florida, they both earned approximately the same amount of money.
What if the trial judge just didn't believe that?
Well,
if the trial judge concluded that your client was just lying?
Well, Your Honor, she'd have to say the former wife was lying too. And I mean, he's got to base it on something in the record.
What about the finding that the trial court made in addition to the findings I've just discussed with you, that the husband dissipated and wasted the assets?
Well, that's another.
Is that not a consideration as well that we should look at in determining whether it should be affirmed or reversed?
Well, Your Honor, as to that $64,000, there's no evidence to support what the trial court said. Because you can look at it one of two ways. The former husband said that was from a home he sold for his mother in Jamaica. It was transferred to Florida. By the way, they have to do business. I'm sure it probably has a lot to do with the drug trafficking and getting money out of Jamaica. And that was testified to. But if you want to believe the former wife, this is what I'm saying, the trial court had to base it on some testimony. If you want to believe the former wife, she said it was his own property. She never said that, it was his premarital property. That's what she said, that he owned from the time he was 21. They transferred it to Florida. The findings of fact also say she had no control over it. She had nothing to do with it. This was all money he spent. Well, if that's the case, then it stayed non-marital, and it couldn't have been a dissipation of marital assets. Either way you want to look at it, he's got to base the findings of fact on something. And if you buy the former wife's argument, she still
So
said.
that finding by the trial court is just simply wrong in your view? That the husband, didn't contribute much of anything to the marriage and then dissipated and wasted the marriage.
Well, I'm just talking about that $164,000. It was non-marital by both testimony. What do you want to say? It was a former husband's mother's home, or it was his own premarital asset that the wife never had any control over, never spent, never knew where it went. In either one of the scenarios, if you believe the former wife or you believe the former husband, it still was not a marital asset that could be dissipated. He could not be charged that $64,000. And again, Your Honor, if you look at the checks that were written and that were submitted into evidence, all the former wife's, remember she made $50,000 a year. All the former wife's checks that she submitted went to the payment and the taking care of the outland land, where her mother lived. There were no checks written for the support and the upkeep of the marital home. Now, based on her own amount she earned and the checks that she wrote for her mother's home, somebody somewhere had to be paying for the marital expenses. It just doesn't add up. I mean, if you look at the math, $50,000 only goes so far.
Well, isn't that what the trial judge described as your client's sleight of hand accounting?
Well, Your Honor, this is not just necessarily sleight of hand. If you look at the checks, I mean, the wife did not earn enough money to support what she said was her mother's home and to support the expenses of the marital home. There's not enough money there out of her $50,000 to do that. Somebody had to be paying for it. The former husband on their income tax had always earned about the same amount of income that he had since they got into the marriage. I mean, if you look at the joint income tax returns, and that Atlan home was always taken as a deduction on their income taxes. I mean, I'm talking about the figures, the cold black and white figures that were submitted by the former wife in the trial court. The trial judge, seemed to arrive at the conclusion that the former wife deserved everything. He treated this marriage as if it was two people living together, that there was never a real marriage, and he wanted the former wife to have it all. And he came up with findings of fact that were not anywhere in the record. I mean, it's got to find some support in the record, and the former wife's testimony does not support what the trial judge found. And again, Your Honor, if you please look at the marital home. I mean, he said he didn't contribute anything to this marriage. Well, he contributed $630,000 to this marriage. And you average that over...
Hold on a second. First of all, he got half the money anyway.
Well, so did she, but Your Honor.
Yeah, and she also paid all the mortgage payments, all the insurance payments, all the downstroke, a whole lot of the house. He just simply can't claim that whole amount. That's just simply not a reasonable
It's
interpretation
contribution to the marriage. That's what I was trying to say, Your Honor.
Yeah, but it's not a $600,000.
It's sold for $630,000. They split the $276,000.
Your time has expired, so if you want to save 7 minutes.
May it please the Court, my name is Marcy Lippincott. Here today represent the appellee, VANSANA, BARRETT, Nelson. Your Honors, I would submit that the former husband has waived any appellate rights they may have with respect to the position they took in the reply brief. Their initial brief was confusing about what exactly they were trying to say. There was no mention of any standard of review. In the answer brief, we said that you must be talking about competent substantial evidence or abuse of discretion. In the reply brief, they said, no, we're not talking about either of those things. We're simply talking about a question of law and whether or not the trial court applied 61.075 with respect to, and they only consider the first part of that, with respect to the distribution should be equal. That's all they say they're saying. But they forget, first off, that the statute says unless there is a justification for an unequal distribution, which is exactly what the trial court found here. He made findings of fact. They don't challenge those directly in their brief. They say in their reply brief, we're not challenging that. So our position, first off, is that they've waived any right they may have to be here today. Their statement of fact is completely skewed in their favor. That's not the way you do things in the appellate court. You write your statement of facts to support the final judgment. And looking at those facts, every finding that the trial court judge made is supported here by the evidence. The former husband was fired from 2 jobs. He committed theft at Office Depot and was fired there. The wife then got him the same kind of job she had with Daimler Chrysler, and he just couldn't get along with others, and he was fired there. He has underperformed, and underperformed. That's exactly what the trial court judge found. There's simply no question here that the evidence supports the trial court judge findings. And again, abuse of discretion was not even raised. I'm not sure why we're here. You should just affirm. Thank you.
Thank you. Counsel?
I raised as a point of view, as a point one of law, whether or not the trial court properly followed the law, and starting out with the premise that this is the statute, the premise that all marital assets and all liabilities incurred during the marriage shall be divided equally. The trial court did not start off with that premise. The second point that I made was the legal standard when the trial court said he went through the statutory, went through without starting with the premise they should all be divided equally, which is what the point of the on appeal was that there's this catch-all, so to speak, where the trial court basically hung its hat, that any other factor to do justice between the parties. And what the trial court found is that any other fact is necessary to do equity and justice between the parties. The husband's history is replete with lack of cooperation, lack of concern, and selfishness on his part as to his family. That's a moral judgment. That's not a legally sufficient ground to award one spouse all of the marital assets. That's not a legally sufficient ground, and I cited cases that said that the ground for any other factors necessary to equity and justice between the parties must be interrelated with the other factors. The former husband said, we dissipated, waste, or depleted marital assets after the filing of the petition. That, if the court wants to say that that was a factor to be used against the former husband, then what the remedy is to subtract that amount from the marital assets. That's not a ground, especially when the court found that it was within just 2 years prior to the marriage, at $64,000. The law says that you can subtract that, if the amount that was depleted, if you want to say that it was depleted, you can subtract that amount from the amount of the former husband's share of the marital assets. The law does not say that that is a ground for awarding all the other spouse all the marital assets. And that's what occurred in this case. If the trial court found that the last 2 years, the latter part of this marriage, the former husband didn't contribute substantially, again, I'm saying, I don't know how much more substantial contribution there can be economically than $65,000 that he put of his own money into the marital home that was sold, for each received $276,000. That is an economic contribution. You can't say that it wasn't. It doesn't say anywhere in the law that you have to go out and get a job where it pays by the hour in order to make an economic distribution. A lot of parties, one spouse might do investments from home over the computer. It's still economic contribution to the marital assets. That's what the former husband did. What if the trial court wanted to say she contributed more during the last 2 years, the latter part of the marriage, he could have given her maybe more of that part of what the marital assets that she accumulated. But if you look at the figures, the fact that she got all of the 401k that she had put in during this entire marriage, that she got all of the, she said that she commingled these funds. She testified she commingled these funds. And commingling of funds is a legal determination. It's not a finding of fact. Whether or not
Oh,
funds,
wait just a minute. Give me that again.
if funds are commingled, which again, she testified they were put into one account. She testified, Your Honor, that they did not separate their finances until 2001. This is her testimony. And up until 2001, they had joint checking accounts. All their money was pooled together. Now, this is her testimony. The trial court just can't pull something out of thin air.
I thought what you said was that that was a legal determination and not a finding of fact by the judge.
Whether or not there's been commingled of funds, he awarded all of her, everything that she had earned, her 401k,
I don't understand why commingling isn't a matter of fact finding rather than a legal conclusion.
well, he didn't make any finding. He didn't make a finding.
Well, then why are you making this argument?
Because because there's nothing to support what he did in awarding her everything that she earned during the marriage. There's nothing. I mean, he didn't find it was commingling or not commingling. If it's not, if he said that it was not commingled, that it was her separate funds that she had earned, it'd be a different story. He didn't apply the correct legal standard in any of this in these findings of fact. That was what I raised on appeal, and that's what I'm arguing today. The court asked me whether or not it was supported by findings, and I say no, the legal standard's got to be something in the record to support it. But what I'm talking about is a legal standard that the trial court failed to use in coming up with this inequitable distribution of marital assets. He had to come up with, I mean, he didn't say that it was commingled, it wasn't commingled. He just said that because based on the last 2 years, he dissipated marital assets of $64,000. That was what the trial court found, and that was under the economic contribution. The former wife, when you enter into a marriage, it's a partnership. You can't sit down after the fact and look at who earned the most. That's not a legal standard in the state of Florida. Who earned the most during the marriage? And again, I mean, you know, the fact that it's what was contributed during the long-term marriage. And the only thing I can think of is that, you know, at-home housewives and mothers would be forever barred from ever getting anything in the state of Florida if this were the law, and that's why it's not the law. It's not who contributed, who was the biggest breadwinner, because there's always a breadwinner. Usually there's one person that earns more money than the other that's a breadwinner. The standard is not whoever's the breadwinner earns the most money gets everything at the end of a long-term marriage. That's not the legal standard in the state of Florida. And it has nothing to do with abuse of discretion. It's whether or not he followed the correct legal standard in coming up with this distribution scheme, and I'm submitting that he did not use the correct legal standard on it.
Your time has expired.
Right. Thank you.